Okay, council, everybody's signing in here. I'm just gonna wait till we have everybody present. All right, looks like we do. So we'll go on the record now in Kent Family Farm versus Vaughn. This is file number 2419708. And if I can have council put their appearances on, starting with Kent Family Farm.
Good afternoon, Judge Paul Slough on behalf of Kent Family Farm.
Good afternoon, Judge Drew Norton on behalf of the Rosemary Curatola Trust and Michael Yunus, defendants in this matter and respondents today.
Good afternoon, Your Honor. Melissa Pronzales on behalf of Mertz.
Good afternoon, Judge Richard Smith on behalf of STJ Realty, DBA, Century 21, and McGuire.
All right, thank you. We're on the record today for purposes of a motion hearing. Mr. Smith, your clients have brought this motion for summary disposition. I did have a chance to review that along with the supporting documentation. Mr. Norton, I did get your response brief. I had an opportunity to review that as well. Ms. Prinsalos, I'm assuming that you're not taking any position either way on this motion.
Correct, Your Honor.
Okay, and then Mr. Slough, I don't know if you're taking a position on it. I didn't get a brief from you, so I don't know.
Correct.
Are you taking?
Yeah, we're not taking a position on it, Judge. And just for the record, too, before you start in on the arguments, Mr. Shimovitz did reach out to us earlier today. He represents Mr. Vaughn, and he indicated that he had a conflicting court appointment scheduled at this time, so that he was not. He gave us permission to proceed, but that he was not taking a position.
Okay. All right. So then I'm just going to limit arguments today to Mr. Smith and Mr. Norton. Obviously, counsel, to the extent that either of you want to jump in, feel free to do that. But otherwise, I'm just going to address those two. So, Mr. Smith, it's your motion. Is there anything you wanted to present today by way of oral argument or to respond to anything that Mr. Norton put in his brief?
Yes, Judge, you should have received my reply brief as well. I assume that you have and have had a chance to review that.
I did not get that.
Yeah, we filed that last, we sent it overnight last Tuesday, which was received by the court, should have been last Wednesday. So okay. I did that within 2 business days of having received it. I think it's relatively critical that you review it at some point in time, but I'm happy to go ahead with oral argument at this point in time. And as I know from having been in front of you in the past, I know that you have reviewed the briefs. Unfortunately, it does not include my reply brief, but I assume that will at some point in time. Seller's response brief does not address all of the contractual provisions that we cite to in our motion, and is tailored exclusively to the statute of limitations portion of the motion predicated on a recent Michigan Court of Appeals decision in Rayford. However, the Rayford opinion applied only to adhesion employment contracts, which contractually shorten statute of limitations. First, it does not prohibit all boilerplate provisions in all contracts, nor does it prohibit all contractually shortened statutes of limitations. In fact, this is the reason why the Supreme Court in the Rayford opinion refused to overturn the earlier Rory versus Continental Insurance Company opinion, which we also cited to, where an insurance contract with a contractually shortened statute of limitations was upheld by the court because it did not include a dominant employment relationship. Second, if Rayford were deemed to be analogous to this particular case, it would appear that sellers assumed the position of employer. Sellers engaged the services of Century 21, not the other way around. They could have chosen to retain any other broker in town to list this property. But more importantly, Judge, neither the brokerage agreement for the listing of this property nor the buy-sell agreement consummated in a transaction are adhesion contracts. The gravamen of the Rayford opinion was that the bargaining disparity between an employer-employee prevents the court from upholding those type of provisions shortening statutes of limitation. The court determined that employees needing jobs are willing to sign anything in a job application and should not be bound by a shortened statute of limitations. No such disparity exists here. Both contracts were negotiated at arm's length. And here, the sellers held all the cards. The sellers knew parcels A and B had been earlier sold. Sellers, secondly, chose not to record any partitioning of those parcels from the entirety of the property in that earlier sale. Sellers, third, chose to retain Century 21 as opposed to countless other brokerages in the area. Sellers also chose not to make note of the earlier sale of parcels A and B in a brokerage agreement. Sellers then negotiated and opted to consummate the second sale of the property without ever disclosing the earlier sale of parcels A and B in a buy-sell agreement. Sellers' only argument made in response to our motion is that they were uninformed because they did not, they negotiated the buy-sell agreement without retaining or consulting an attorney. But that was sellers' choice. And they did so despite their written acknowledgement in the buy-sell agreement that they were told to the contrary. These are many of the same reasons the Supreme Court refused to overturn Rory when it upheld a contractually shortened statute of limitations in an insurance contract. There existed no such disparity in the bargaining positions between those parties, the person who bought the insurance policy and the insurance company. Rayford, unlike what sellers characterize the situation to be in their response brief, does not stand for the proposition that all form contracts are adhesion contracts. This is a very ordinary sale of property, necessitating a very ordinary brokerage engagement contract and a typical buy-sell agreement. This is why form contracts are utilized. And as a side note, Your Honor, for Rayford to be applicable in this case, sellers would be seeking to engage the equitable powers of the court. To be an adhesion contract, the relationship between the parties would need to be such that the contract is unconscionable in equity. But here, sellers have unclean hands and shouldn't be permitted to engage the equitable powers of the court. Sellers never recorded the earlier petitioning of parcels A and B, which should have placed the world on notice that there was an earlier sale, at least a possibility for a sale. Secondly, the sellers resold the entirety of the property to Vaughn without making any written disclosure in that buy-sell agreement. But maybe most importantly is that after this litigation was filed, sellers never sought to interplead to the court the very money they received from the first sale of parcels A and B. Rather, they pocketed a double recovery. Finally, Judge, as I indicated at the beginning, Rayford applies only to contractually shortened statute of limitations. Yet our motion asserts the sellers contractually waived any claim against the broker and that the contracts here clearly identify the property to be listed and the property to be sold. Seller's brief doesn't even address that aspect of our motion. In the final analysis, absent this being an adhesion employment contract, the statute of frauds requires the court enforce the four corners of the documents. Century 21 was engaged to list an identified parcel of property in a brokerage agreement. The buy-sell agreement then sought to convey that same property. The parties are now bound by those documents. Thank you.
All right, thank you, Mr. Norton.
Yes, thank you, Judge. Not surprising to have a different view of the breadth of Rayford, its rationale, and its applicability. I view Rayford as a major shift in the law of whether it's adhesion contracts, unconscionability, reasonableness, unequal bargaining power, whatever equitable principle we're talking about. I think the Supreme Court indicated a major shift. No question, Rayford involved an employment contract. It sure did. So it was a big opinion. Unless I missed it, I didn't see any, and I don't think I did because it would have been, we would have heard about it. I don't think that the opinion limited its holding to their particular facts in any way. I think the rationale of Rayford applies in many contexts, including the two we have here. By the way, I do reference not only the statute of limitations issue, but the waiver release language, the beginning of the paragraph where I go into the analysis on reasonableness regarding the test as to either provision. That being said, our argument is that the rationale of Rayford applies to both the statute of limitations provision here and the waiver slash release. We are not arguing that all form contracts are adhesion contracts. We are arguing that the provisions of these contracts are. And incidentally, it is not insignificant that these provisions are in the buy-sell agreement, which is a contract between the buyer and the seller. Even though it's on Century 21 letterhead, they're not a signatory to that agreement. It is not in, those provisions are not in the listing agreement. I will also note, Judge, that this mistake as to at least the part of it regarding the the legal description that was attached to the buy-sell and ultimately the warranty deed. That mistake wasn't discovered for 2 years. I do discuss the reasonable test, which Rayford applies to, again, admittedly, the employment contract. I am no question asking the court to apply these standards, these principles, and this rationale in this context. I believe the Supreme Court would do just the same, and I'm asking Judge you to extend it. No question about it. With respect, finally, to the fact of the split wasn't recorded. I wasn't part of that. I'm not, frankly, don't know that that's true, but I'll take Mr. Smith at his word. But the notice to the world really isn't relevant here because they had actual notice. Mr. Jonas, he's got an affidavit to that effect, at the kitchen table, said to Mr. McGuire, we split the property, we sold part of it to Kent Family Farm. I didn't find this out later, but if he were here, he would be testifying that more to that point, fact that he saw Mr. McGuire actually write it down in his notes, but that will have to be for another day, maybe, depending on what your honor does. So the point of that is Century 21 and McGuire had actual notice of the split and the sale. And it is on that basis, we believe they were negligent in the paperwork they did. And it was one of the errors that were made, not the only one in this whole process. So Judge, I am asking you to extend Rayford to this scenario, and whether it's under C10, I believe there's a genuine issue of material fact, and that is on the notice issue. They didn't argue C10 really all that strongly, but under C8, I think you can under Rayford deny this motion. Thank you, Judge.
All right, thank you, Mr. Smith.
Thank you. I'll be short. That is an incredible, gross overreading of the Rayford opinion. The entire predicate of the court's opinion was the bargaining disparity between the parties. The court spends the entirety of the opinion talking about the disparity between the parties. Plaintiff can't now ignore that. And the entirety of the opinion went to the statute of limitations, not other provisions of the contract. In fact, the court goes on to an analysis of what the factors should be in the court determining if the statute of limitations shortening is reasonable. And then if it is deemed to be unreasonable, how long should it be? Plaintiff wants to ignore all of that. It is the decision about why those contracts in an employment setting are deemed to be unconscionable because they are adhesion contracts does not apply here. The second point that the sellers make is that they should be entitled to invoke the discovery rule. Well, as their attorney has indicated, everything that was there to be known by the sellers knew. They knew that the parcels had been sectioned off and partitioned from the entirety of the property. They knew all of this. They can't now claim that they needed to have that information in order to proceed on the statute of limitations within the appropriate amount of time. But none of that explains why we shouldn't be looking at the four corners of these documents to determine what it was that my client was called upon to list and what property was sold. That's all bound by the statute of frauds and the language of the contracts that were utilized and signed between these parties. That's all I have. Thank you, sir.
All right, thank you. I'm just going to take 1 minute, Mr. Smith. I want to check on that brief because I should have seen it. If I have no reason to doubt that you didn't file it when you said that you did and overnighted it.
Right.
And I've got it's until my next hearing. So I'm just going to ask all counsel to remain on the line. I'm going to take about 10 minutes and I'll be back on the record. Thank you.
Thank you.